for the late start. We're on our way. Just jump onto YouTube and I'll bring this up on the screen. I'm also going to try and run the thing amplified, just for volume reasons. Me with my funny Kiwi accent. Let's go. So it should be here. It should be here. My live stream somewhere. Live now. Here we go. Turn the volume off there. Let's do this. So today we're going through the second of 5. Yes. Can I use an actual microphone? I can hold this to here for the recording, but it's not for the amplifier. This I can change the volume for if we want my voice to be louder in this room. Yes? Okay. That I can do. How's that? Okay. I think what I'll also do is I'll sit on this stool here. How's that, guys? Is that a little easier? All right. I appreciate that I'm the only person in the room with a New Zealand accent, so I'll try to both speak a bit quieter, a bit more clearly, and we'll amplify that somewhat. So, this particular session is about contractual terms. These are the things that make up a validly formed contract. So the last week we talked about formation, how these things come together. This component is looking at what a contract is. Remember that when we think about those elements of the offer and acceptance, the offer is a list of terms, of promises that the two sides are coming together to exchange. And they can be things of that they promise to sort of give to each other, or they can be promises to not to do things. I'll pay you $1,000 if you don't. Sue me for breach of this, that, or that. Sue me for running over your cat or something similar. Okay, you can promise to do things and not do things, to give stuff or not give stuff. Okay, and so that, as you could imagine, when you've got a contract in place, knowing what your obligations actually are is really important. It's a very important thing, particularly in situations where this comes up in business, which almost always involves written contracts. Now, we know from last week, contracts don't have to be in writing. They can be oral. They could be in writing. They can be in writing over multiple documents that collectively forms one contract. And they can be a mix of the two. But either way, interpreting what is in the contract requires the knowledge of a bunch of rules that we're going to go through today. And some of them aren't actually intuitive. Sometimes when you pick up an instrument, a contractual document, the words that are contained within might not mean what they ordinarily and naturally mean to us when reading it. There's a few tips and tricks for doing this. And this may make a difference for you guys in your professional and or personal lives. As with the other areas, to start with a very, very basic definition of what a term is. A term is just some sort of promise. It's one of many obligations contained within a contract. Right. What is the minimum number of terms you can have a contract? It's a good question for you. What do you think the absolute minimum number of terms you can have would be? No, that's elements, that's formation. So if you've got a validly formed contract, it's 2. One person has to promise something, another person has to promise something. There has to be, in theory, at least 2 terms, even if they're written in one sentence in an instrument. The obligations for both parties that have been incorporated inside this contract. Now that word incorporated actually has something of a technical meaning that we're going to go through, because sometimes, especially when you've got a contract which is spread across multiple physical documents, you have to work out whether or not some of those written things or some of the statements a person's made, and oral statements, whether these are included as part of the contract or not. And this test of determining whether or not a term is in a contract or not it's a really important test for us to go through and do to determine whether or not things we agree upon are included in the contract. We call those things that we agree upon express terms. Those aren't the only type of terms that we're going to have in contracts. There are other ways that obligations can be included in the contract, and where the parties don't agree. For example, you and I could come together. I will come and work for you for $10 an hour. Okay, it's a pretty straightforward contract. I'll come work for you, say cleaning a house, and you'll pay me $10 per hour that I work. It's a pretty simple sort of contract. What do you think is problematic with that in Australia? No, it's not the time frame. Minimum wage. Where does minimum wage come? It comes from a piece of legislation called the Fair Work Act that says you can't, in any state or territory in Australia, work for less than the minimum wage. $16 and something an hour, I think it is. And so that, even though we didn't agree upon that, in fact, we deliberately don't want to agree upon that. I'm very happy to come and work for $10. I would have worked for $5 now, but I've negotiated my way up to $10. Nonetheless, that minimum wage term is incorporated into the contract. We call that an implied term. And we'll talk about them a bit later in the session tonight. So there's some other rules that we're going to go through there. And each of these, I don't want to use the word terms, concepts, areas of law, legal rules or principles, each of those you're going to have to know in regards to your online test. You're going to have to know how to explain each of those things in a few sentences, both the basic rule and, for most of them, some of the sort of sub-rules that lead up to that, some usually exceptions of some sort to the main rule itself. Okay, so just as an overview, I'll just go through and explain each of these. An express term are things that the parties agree upon. However, these have to be classified in some way, because express terms, the things that we agreed upon, have to be incorporated into the contract, and there are rules for that. There are rules for going through determining whether a particular statement is in a contract or not in a contract. The parole evidence rule is, strictly speaking, a rule of evidence, but we learn it in contract law because it only involves contracts. It basically says where the parties agree to put something in writing and enshrine their agreement in writing, all other statements, oral or otherwise, cannot be used as evidence. Evidence. They cannot be used as evidence as part of it. They do not form part of the contract if we agree to enshrine it in one document. That's the parole evidence rule, and I'll talk about that in about half an hour. There is some special rules, though, to do with incorporating where there are multiple documents. We have to learn about the effects of signature at number 7. We have to learn about some sort of exceptions to that. In that sometimes, even where a party signs something, if the contract is so awful, the other side has to bring the person signing its attention to it. We call those onerous clauses, very, very, very harsh clauses. There are certain rules to do with notice in regards to that. And there are also certain rules in regards to exemption clauses. They are mechanisms that parties use in contracts, that put terms into contracts to try and exclude their liability, usually for breach of contract. They try and reduce the amount they're going to have to pay and the extent of fault that they're going to be responsible for when things go bad. We call those exemption clauses, and I'll talk about those. These, however, are all to do with what we call express terms. These are things we agree. The example of the Fair Work Act, bringing a minimum wage, that's actually known as an implied term. We didn't agree upon that. So that forms its own separate area in terms of obligations that are forced upon the parties, and that can come in a variety of ways. The most important one is through statute. A collateral contract is a baby contract that sits aside the main one. Usually, this is done because courts don't want to be the destroyer of bargains. So if one side agrees to enter into a contract and somebody promises to give them something, if they enter into this main contract, the courts will say, sure, we will hold this main contract and uphold it. We'll hold this as completely valid. But if the side promising something for a person to enter into this main contract, we are going to say that, look, assuming the side reneges on this promise and doesn't actually do it, one person enters into the main contract after some third party or another person promised something. If you think about it, that's a contract itself. And we call these baby ones collateral contracts. Then we're going to spend a reasonable amount of time later on going through interpretation rules, how you go about reading contracts that are valid and that exist, going through the terms. Okay, so we'll start this by talking about express terms. Express terms, it should be on the screen soon, these are obligations that are incorporated, in other words, brought into a contract through one of these three ways, all right? Because when you've got just one document, it's really easy. When there's a series of statements and promises that go into just one physical document, however many pages it is, that's really good evidence of what the contract is. It gets a little trickier though when we're dealing with one party saying, oh, some of the terms are here and some of them are over there. And one of the examples that we use for this are what's called the ticket cases. When you go and get a ticket from a parking machine, and it says all of the terms and conditions are printed over there somewhere. And there are rules for determining whether or not that's actually validly incorporated into the contract that you make when you take the ticket out and drive into the car park. There are some rules for that. That's called incorporation through notice. You can do that, but some of those rules are a little bit commonsensical in terms of the actually giving notice, usually ahead of time. It's pointless saying, oh, the terms and conditions are contained inside the box, for example. You've got to buy the product, open the box and see them. You can imagine that some aspect of this, and all of these rules derive from this idea of fairness, the meeting of the minds that we have as two people forming a contract. If we can't know what the terms are, it's going to be problematic. And the third one here is to do with the course of dealings. This is where the parties don't expressly say, these are the terms of the contract, but they may have had one contract and then another one and then another one and then another one, even though they don't agree and have all of the elements of the contract, this offer and acceptance and so on. What the courts have said over a long period of time is that, look, if you've got this course of dealings with a particular business, we as a court can actually deem that the documents, the various statements that have been made, can actually be incorporated, expressly incorporated into the contract. Talk about that in a bit. But the first thing we need to look at, though, are actual statements made by one party to the other, because this really goes to the heart of it. Because these statements that one person makes to another close in time to the formation of a contract. So, for example, if, and again, here's an example of going back to me buying a boat. You've got a boat, I've got $8,000, I want a boat, you want $8,000, great, let's form a contract. Okay? So if we think about this, and here, we're thinking of strictly an oral contract here. Again, it doesn't matter conceptually whether it's oral or written, but we'll just start with an oral contract. This seems like a pretty straightforward sort of a contract. What's the consideration? What, anybody?
The remuneration will be paid.
Abhishek?
Contract.
Which?
Simple terms.
in simple terms, we've got consideration here. What are the two things each of us are promising? A boat and $8,000. It's pretty. Those are the two things. The very minimal number of terms. We might want to have things like, I'll meet you at my house to pick the boat up, perhaps, between this particular time, or at a particular time, maybe. But certain other things that you might say about your boat at the time we're forming the contract might have some form of legal significance. For example, if you told me that your boat is the fastest boat north of Caboolture or Brisbane or Sydney or wherever, okay, you're telling me this boat is the fastest boat that you've ever seen in your life. What kind of statement do we call that? We call that puff. It's an exaggerated statement or claim that no reasonable person would ever think has some sort of legal effect. Okay. How would it work though? If instead of saying this was, it's the fastest boat you've ever seen, what if you were more specific and you said, this boat can do at least 15 knots. Then you've got to start and think, well, hang on, is this statement that's been made in this situation, is this going to have some form of legal effect? Does it form a promise? And so this, if we think about this, particularly in terms of oral contracts, a statement that's not completely exaggerated, it's not completely outlandish, it might be, as part of our negotiations, when you say this boat can do 15 knots, that you're actually guaranteeing the truthfulness of that statement. And that's a really important phrase, a way of looking at it. If the courts reckon you're guaranteeing that it can do 15 knots, you guys know what I mean by knots? That's nautical miles, I think, per hour.
So PUF doesn't register, representation does?
Well, this is just it. These are the 4 classifications of statements that we can have. We can have puff.
You can have them in the contract?
No, only terms, the third one, go into the contract.
Make it into the contract except terms?
Except terms. Okay. Term, and there's some rules I'll talk about in a few minutes.
Yeah.
Terms are statements where the courts reckon you are guaranteeing the truthfulness of. And this is different and distinct from mere representations, which you are not. Now, before we go any further, I will have to say that these representations can still have legal effect, but they are not terms.
Like the 15 knots?
Like the 15 knots. The courts don't reckon the 15 knots is a term because you didn't guarantee its truthfulness. But the courts also think that this particular statement was designed to mislead the person, me, into entering the contract. It can still have some legal effect. We'll actually go over that next week.
Even if you can't prove it?
Assuming...
I have a report that says, he says it goes 15. I said, no, it didn't go 15. Then
that's right. It's a he said, she said. And what the judge was going to say, because these are questions of fact. Who's lying? Who's telling the truth? Or, to be honest, in most court cases, you've got 2 parties. Usually, it's who is mistaken, whose memory fails them the most. It's quite rare that people go to court and lie. It's a criminal offence to lie in court. Yeah, if you go and do that, and again, you guys as business people in Australia, in Queensland,
anywhere in the world.
it is, but you're going to find in places where there is a higher trust amongst people in business that the consequences for basically lying, you're far, far more likely to be found out. You just will. There's fewer people. There's more rigorous policing. The records are better kept in courts, so people can go back. They're all public. Everything you say goes through the court system and is recorded. Even, by the way, if you're in the courthouse and there's no one else there. So if you're in the courthouse and you're gossiping to your friend and telling them where you hid the bodies, Just make note, that's being recorded. But here, this idea of statements that are made around the time of formation either being terms where you guarantee their truthfulness and there's consequences if it's not true. That's a term. There is always legal consequences if a party breaches a term. They don't do what they say they're going to do. Whereas representations, again, the rules, we sort of classify those into mere representations and misrepresentations. They can have some other effect. There's also another area called estoppel as well, but I've not included that here. It's not important for the time being. Now, if something is a term and it turns out to be false, the boat can't do 15 knots, that's easy. It's easy. I can just go to court and ask for some money. I can sue you for breach of contract. Doesn't matter if it's not your fault. By the way, contract law doesn't care about fault. If the boat put it in the water and I can prove that it only does 12 knots, I can go to the court and ask for a remedy. It might not be very much money, but I'm always going to get something. And again, we'll talk about this when we do damages and remedies in 2 weeks' time. Or 3 weeks now because of it. Right, now that final thing here, this collateral contract. If instead of, as well as saying, hey, I'll buy your boat for $8,000, but I'm not really sure about it. And you say to me, or even better, if you came and said, hey Simon, if you buy this boat, I'll give you all of my textbooks at the end of this year. All right? This obligation to make me go into this main contract, this is called a collateral contract.
So is it like an added value?
It's a separate agreement. If you think about it, what's the consideration you're offering? All of the textbooks. What's the consideration I'm offering?
The boat.
No. It's my consideration is not the boat itself. My consideration is that I promise I will enter into this contract for the boat for $8,000. And the reason why the courts do that is because they can cleanly analyse each of those obligations. They're separate and distinct things, each capable of breach. So if I enter into this boat, pay the $8,000, but you don't give me the textbooks, I've got no remedy here. I've got no beef to do with the boat. It's nothing to do with it. That contract, assuming it's been performed, is done. I can't take the boat back. It's actually unrelated.
It's called a deal sweetener.
Yeah, and that has legal effect because this is a contract. Offer, acceptance, intention to create legal relations, mutuality. It's got the elements. Got consideration flowing between the parties.
What is the benefit to the other person? I missed that part.
The benefit to you,
One is offering the textbooks, right? What is the benefit to the other person?
if assuming that you're her friend, you want this contract to go through. The benefit is from you is that you want this contract to go through. It's the reason why we have this collateral contract. That's the benefit to it. Takes a little bit to get your head around because there might be reasons. Say this is your sister. You want her to sell this boat because you hate the boat and you want her to pay you back some money that she owes you. Sell that awful boat and give me the $5,000 you owe me. So you might have a strong incentive for me to enter into a party. This happens a lot more often than you might think. Unlike some of the stuff from last week, this stuff does happen. This idea of a collateral contract will actually come up in some of the cases that you'll read. It's a baby contract where one person's consideration is to enter into a main big contract. That's how that works. So, I've actually got slides for each of these, so I'm just going to go through and talk about them. So, apologies if I'm kind of repeating myself. The idea of puff has a few rules associated with it. And that statement at the top is from the same case we had last week, the smoke ball case. You guys may recall the smoke ball case was where this company, this Carbolic Smoke Ball Limited, put £1,000 into a bank account and said, If anybody buys our product, uses it properly, and gets influenza, we will pay them £100, which is a huge sum of money in 1890. And again, I made the comment, one of the times there was a worldwide pandemic. It's very a little topical, sadly. So some woman, Mrs. Carlyle, took them up on that. And one of the arguments they tried to make in court, this carbolic smoke ball company, was that, this was mere puff. Don't be silly. Of course we're not going to give people £100. That's equivalent of it's $20,000 or $30,000 now. Of course we're not going to pay that much money if somebody gets the flu. That's ridiculous. And the court said, no, you're wrong. And the reason you're wrong is because you actually went and put the money into a bank account. You can't argue that it was an exaggerated statement of claim that no reasonable person would ever think has any legal effect if you actually went and put this money in this bank account. And it sounds a little bit strange. And last week I talked about the PepsiCo with the Harrier jet. If they had said, we put £1 million, more money than the entire Bank of England, into a bank account, and they didn't do it, then they were far more likely to succeed in arguing that it was puff. But they didn't. They put £1,000 into a bank account, and that was believable. Of course it was believable. They actually did it. So that's a key thing to note. It has to be so outlandish that no reasonable person, and again, this is the subjective test, objective test, a reasonable person test. And so courts have gone through and analysed some of these statements. Eveready and Gillette, who knows who those two companies are?
Yes.
The battery companies. And so, again, for those that end up in marketing and actually end up doing advertising, if you're making statements of claim to differentiate your product, make them outrageous, because if you don't, they can have legal effect. And here, like the plane giveaway for Pepsi. The Harrier jet, you needed to buy 25 million bottles of Pepsi, is fine. Not 2 million bottles, because the Harrier jet was worth it to buy 2 million bottles of Pepsi, and someone did. I don't know what happened to the Pepsi, by the way. I have no idea what happened in that case. So, this statement here, batteries last up to 4 times longer. That was one of the arguments they had when, interestingly, not the ACCC. We have a body in Australia called the Australian Competition and Consumer Commission, I think. They are the ones who usually sue parties for misleading and deceptive conduct. This sort of statement in their advertisements. This is rare, this case, in that it was actually the competition. So the other battery company said, oi, you saying that your batteries last 4 times longer than ours is not a statement of puff. It's saying your product is 4 times better than ours. If you're doing that, and it's not a statement of puff, it's an actual statement that you're making to the world that's going to lead people into error, then that's misleading and deceptive. And it's actually it gives the other side a remedy. You can sue them and seek some form of compensation. We'll talk about the statutory rules in week 7. And real estate agents. Who's ever had to deal with real estate agents? Or does anybody have any family involved in them?
I worked in real estate.
Oh, you've worked in real estate.
And we are so full of shit.
It is the... almost all of you guys have done business management as a discipline. All right? And I don't know if you've been exposed to this, the 4 quadrants of work. If we think about the types of work that people do, it comes in 2 axes. One axis is for the extrinsic reward. In other words, how much money you get from doing it. The other axis is from the intrinsic reward. So how much value you get out of doing it. So if we think about that, you can categorize jobs into all 4 of those things. And so some jobs people love doing, but they don't pay very well. Childcare is the classic example. Although these days, possibly all forms of teaching relative to other roles have become less and less extrinsically rewarded, and people usually just do it for the love of it. Jobs people do for the love of it. And art. So childcare and art, doing things with pets. So my mother, who I'll talk about at some stage, a variety of things, who has a pet transport business. There's a little bit of extrinsic reward, but not much. She does it for the love of it. All right, that's one axis. Now, on the opposite scale of that are jobs that people do only for the money. They're horrible jobs to do, but they're very well paid. Sales jobs.
That's not true.
Sales jobs, well, not true?
Attack you here.
Not.
It is a very rewarding job.
It is very extrinsically rewarding.
It requires a certain set of character.
It certainly requires a set of character. I'm not. Do you disagree?
It's not a job that is unpleasant and highly paid. It is if you don't like doing it. But
That's right.
If you like the freedom for it, it's the most amazing job. If you have
It
the
is.
character for it,
Yes.
to be
So,
outside all the time, to sit with people, to
yes.
do that.
Yes, this is right. You find, though, there is a trend, and this is backed up by literature. I'm not just pulling this stuff out of wherever. There is a trend towards people going into sales roles for the extrinsic rewards.
Of course, it's an extra profit.
Yeah, that's the thing. That's the people do that. So, selling real estate. There are also some jobs, dangerous jobs. Sometimes people just love the danger, but often those are the sort of things where they. Sales commentators, yeah, true. But generally, we sort of say these are extrinsically rewarding, but not usually. Again, if you're one of those few people that gets value from it, good on you. Generally, people don't. Then you have the ones which are neither. What sort of jobs are not intrinsically rewarding and are not well paid? They're things with low barriers to entry. Good old Michael Porter. You guys, Michael Porter, familiar to you guys?
What is it?
Michael Porter? You guys not heard of Michael Porter? You should have, at some stage in your management literature, he's the most famous business strategy guy, probably ever. Okay, it'll come up. Either way, things that require no skill and aren't, basically that don't have a high barrier to entry. So a lot of jobs, hospitality, retail, transport, those are the sort of roles. Whereas the complete opposite of that, jobs that are very well paid and have high intrinsic rewards, the top doctors, accountants, lawyers, maybe, not sure about that, judges maybe, architects. And you can think about it, jobs that require a lot of education, a lot of human capital investment, and generally quite a lot of aptitude, very high barrier to entry, usually with professional requirements. The reason why I'm saying this is that real estate, and again, I'm particularly narrowly targeting real estate here, has a reputation as an industry to attract people who are good at bending the truth on things. Again,
That's all salespeople.
it's also possibly all salespeople, but in particular, commission salespeople, which most.
Any
Yeah,
sales job that is not commission-based is not a sales
it's not a sales job. Well, that's a good point. That's a good point. I argue that the argument there is, for the recording, is that any sales job that's not commission isn't a sales job. This actually matters in law. I'm not just talking about this for the sake of being heard. The reason it matters is when we come to analyse various industries and the expectations that you have of what people do in those industries. Talk about more of it next week. We'll do misrepresentation. But when you are going and buying a house, do you expect the real estate agent to tell you all of the bad things about the house or the area? No, they don't. I don't know if any of you guys might be a bit young for this. The movie Seven with Brad Pitt and Gwyneth Paltrow. Yes, and Morgan Freeman, sure. That's right. And they went through their house. The train would go past there all of the time, except for one half-hour gap at one point during the day, and that was the day the real estate agent took them through to show them the house. Those things just do it. Or you find out your house is on the flight plans, and the real estate takes you there. I'm really from Auckland in New Zealand, and the harbour is very tidal. Some of the suburbs look beautiful when the tide's in. When the tide's out, it's those awful mud flats. And so if you're a real estate agent, you think about the tide when you come through and do that. So, these statements, and this came up in this case here, it's to do with real estate agents, where the court has to work out what is puff and what is not. Immaculate style, sure, that's puff. Usually those sort of statements are very vague. But when you start to be more concrete about what it is that you're saying, and here, perfect presentation, nothing more to spend.
Yeah.
That's where you're starting to be more concrete about what it is that you're saying. That is where the courts can determine that you've moved from merely exaggerating statements to differentiate your product to making promises that need to be guaranteed. Okay, so that's puff. That's probably the easiest when we've got when we've got statements that are made in and around the time of formation of a contract. We need to classify them. And so this is the first one, and you guys will be doing this for your examination at least, possibly in your assignment too. This classification process is important because we need to know when we're working in a business environment and we're making statements everywhere in the world, advertising, when we're sending emails to people who are asking us questions about our products, we need to know whether or not those statements are going to have legal effect. Okay? The first one, puff, is a pretty simple rule. The next one, though, is not. The next one, yes, a question, yes. Carlisle's case, yes. There they said, in Carlisle case with the smoke ball, it is not puff because it was serious. It was believable. And the reason it was believable, they actually went and put the money in a bank account. You can't say it was a silly, exaggerated statement if they actually did that with the money and they actually put it in that account. It was not. If the third party's looking at it, the third party would probably not think that this was mere statement or exaggerated statement of claim to differentiate the product. No. It was concrete. It was believable. So believable that it actually happened. Does that make sense? Okay. So the key thing to note here, leaving aside puff from this point, and I'll also leave aside collateral contracts at this stage as well. We'll leave aside that and estoppel. Because when a statement is made in and around the time of formation, we have to work out whether it's a term or not. Now, if it's not a term, it may still have some form of legal effect. And I've put seven different ways that it can have legal effect. If it is a mere representation, no legal effect. If it's one of those other things, there's 7 things, of which all but the last one we're going to talk about next week, 2 weeks' time. All right? In all of those situations, of the 8 items in that list, it's not a term. If it's not a term, you're not guaranteeing its truth, and if it's not true, you're not going to be sued for breach of contract. May still have some other form of legal effect, but it's going to be some other area of law, or rather, usually some area of contract law, that's going to give the other side, possibly, some sort of remedy, some money or something they can do in regards to that.
Case-by-case basis?
Oh yeah, it is. There's some rules for determining this, and so the judges have talked about.
An exception to the rule kind of thing.
I haven't talked about what the rule is. It's actually in the next slide.
Okay.
It's where a statement is made in and around the time of formation. Is it going to be a term or not? That's what we're trying to work out. So again, this 15 not statement with the boat.
So this we're talking about verbal?
Verbal or written. You can have a written contract, can be a variety of documents. So an example, for example, is if you receive in the mail a document that says, come down to Harvey Norman, our computers are half price.
Yeah.
And you go there and you find that the computers aren't half price, for example.
Yeah.
If you can argue,
That's a term.
if and only if you can make an argument that that is a term, then they're going to have to compensate. If you go and buy a computer and they say it's half price, right, and they sell it to you for full price and they take 100% of your money and it's a term of the contract, you can sue them. And the amount you can sue them for is going to be the difference if it's a term. Again, and these are the rules for incorporation, because then there's rules. It's on the next slide. The test we use for determining whether or not a statement is a term or not is what's called the contractual intention test, because in almost all situations, we, as the party that's been ripped off, so sorry about this with the boat example, if I find out that my boat only goes 12 knots per hour, I want some sort of compensation, I want some sort of remedy, I want some sort of result.
Yeah, but usually they say, like, if you're saying 50% off,
Yep.
they say these are 50%, these are 20%, these
Yep.
are 30%.
Yep. So assuming you've received something in the mail, the argument you're trying to make is the statement in the mail part of the contract, or is it separate and distinct? Or perhaps a better example would be not a statement in the mail, but one that somebody's handing out outside the store. They're walking past the store and they're giving a pamphlet. Everything in Harvey Norman is 50% off. And you walk into the store holding this, grab a computer, put it on the thing, it gets paid for, and then you say, whoa, no, 50% off. Because if you think about it, if this is a term of the contract, and they've gone and sold it to you for $1,000 instead of $500, you can sue them. It's a term of the contract. They promised this. If and only if it is incorporated into the contract. If it's a term, you're always going to get a result. You're always going to get money.
But if they're sending you pamphlets,
Yep.
in the end they simply said terms and conditions apply. We
Sure.
can't do anything about that.
No. In fact, that's what they will usually say, carefully at the bottom, as they usually will say things like, this is only a limited amount applies. This is not intended to be a term of a contract. Please see in store for more details. Little things like that they'll put in there. But strictly speaking, those little things at the bottom might not have any legal force or legal effect. All right. So when we're going through and doing it, for example, if you can't read them, if they're so small you can't read them, the reason for that is that usually when someone hands you a pamphlet, you're not signing it. If you sign something, and again, I'll talk about that later today, it's quite a different kettle of fish. It's quite a different situation than when somebody gives you an instrument, a document of some sort. These things can be incorporated into the whole contract. And for you as the person buying it, that is a good thing. And so this test that we use for determining whether or not a particular, again, I use the term statement or representation, is incorporated into the contract because they can be oral and they can be written. You can have situations where people can have a series of oral statements or a series of written statements or a combination of them. And they can collectively form one contract. We're trying to work out whether or not those statements are terms or whether they are just a representation. And that's not to say that those representations won't have any legal effect. They often do, but they're not terms. Term is the best one for us, because if it's not true, if this is a term of the contract that this boat has to go 15 knots and it doesn't, I'm going to go to court and I'm going to win and I'm going to get a result. And that result usually is going to be money. Maybe some other remedies I can get to. Usually I'm going to receive some form of compensation. Okay? We want things to be terms when the other side hasn't done what they said they're going to do. That's the ideal situation. From your perspective, you're going to be arguing like crazy that it wasn't a term. Again, argue that it was an exaggerated statement. No boat goes 15 knots. Probably not going to win on that one. Puff, probably not going to work. 12 to 15 knots. It's not so exaggerated that's unbelievable. So we would use these rules here. And so the courts look to these 5 things when they are trying to determine whether a particular representation that's made is a term or not a term of the contract. We call this the contractual intention test, and the courts look at each of these and weigh them up, usually the extent or the degree of each of these particular things. So the first one is to do with special knowledge or skill. Oscar Chess and Williams was a case involving a car, Morris Minor, I think it was. Don't quote me on that. A Morris of some sort. And in this case, the guy was going up to a car dealer to sell his car. And this is important. Which of those two parties knows about cars? The car dealer. Now, and again, the courts took this into account. They said, look, if the guy going up to the dealer was also another dealer, this case would be decided differently, maybe. All right? But in that situation, the guy didn't know. So he took the booklet from the glove box that said, this is a 1948 model. Right? As it happens, it wasn't a 1948. It was like a 1935 model. It was quite a lot older. And the car dealer sued I think it was Oscar Chess. They sued Williams and said, "Oi, you promised us that this was a 1948 model." And there the court said, well, no. The guy had no idea. He's not a car dealer. You're the car dealer. You should know. And so that's this special knowledge or skill. If you have special knowledge or skill in regards to something, and a promise is made by one or the other parties, the courts are going to take this into account. How much you actually knew about this. So going back to the boat example,
Well, how did they get to court?
it went to court.
Buying the car.
Yep. So the car dealer was buying the car off this guy. Then later out. Oh no! This is, look at the year. The years. This was in the 1950s. There's no registration then.
It says 1982.
No. Oscar Chess and Williams. 1957. 57. Sorry, it's a bit tricky to read that. Yes, yeah, special knowledge and skill. And so there the court said, look, in this situation, with us going back to this boat example, if you're a boat dealer and you're saying, oh, it definitely does 15, or rather you say that it does 15, it turns out to only do 12, you're going to have a much harder time trying to argue, oh, it was merely representation, I didn't actually promise that to be a term. The courts are much more likely to smack down on the person who has the particular knowledge or skill in this situation. If the parties are equal, it's not going to be quite so, start again. If the parties are both equal, we both know a lot about boats, the courts are also going to look at this and say, well, if you both know about boats and the statement has been made that it does 15, when you're going through and analysing this, you both knew this. It's probably still more likely that the courts are going to rule in this situation that it is a promise that's been made. I'm buying it. I know how boats work. I know the speed of the boat. Sure, your boat could do 15. Sure. But if I have no skill about boats, it's much more likely the courts are going to look at this and just go, whoa. When the person buying it hears 15, they're not going to know. So the whole rule of caveat emptor is thrown out the window there. Okay, this is actually the exact thing that happened in the next case, because the next thing the courts look at is the style of language that's used. This is important. Did you say, oh yeah, I think it can probably do 15 knots? Or did you say, it absolutely can do 15 knots? The language matters. Yeah, it does. And in fact, J.J. Savage and Blackney actually involved a boat. It actually involved somebody saying, I reckon it can probably do 22 knots. And there the court said, not promissory enough in that situation. That's an important factor they'll look at. Time matters. Did you make this statement at the time we were forming the contract, or was it something you mentioned to me a year ago? Because if you mentioned it to me a year ago, the courts are far, far, far less likely to incorporate it into the contract. Going back to the Harvey Norman example with the pamphlet, If you get it in the mail and you wait a week, much less likely the courts are going to incorporate that as a term into a contract. If you've got it, then you had to go to the store at some stage later. Time matters. It doesn't matter whose fault it is. It doesn't matter, I just took a week, this seems good, or not. The passage of time itself, and obviously the type of contract matters too, but that's going to, it's going to matter. And again, it's to do with the time of formation, not the time the goods were passed or inspected and so on. Writing. Item number 4. If we want to be serious about something, we put it in writing. Writing's the best form of evidence, and it's much more likely the courts will place weight on a representation that's made if the parties put that representation into writing. It's going to have a lot more weight. With the 15 knots, if you wrote this down and read to me that it did 15, the courts are going to place so much more emphasis on that than they would if it was merely an oral statement.
They argue that it's not. If they put it in writing that the vote can go 15 and it didn't go 15, can they still go to court?
You can.
Why would they go to court if they lose?
Again, it depends. In this situation, if we put it in a single contract that says, this is a contract I promise the vote does 15, yeah, very, very hard to argue that that's not a term, expressed term of the contract, right? You're almost never going to be able to do that. What can happen, though, is if, for example, we had a series of emails, an email conversation that happened over a period of time, all right? And if it's in writing, again, much more likely the courts are going to say, you promised it because you put it in writing. They actually look at the weighting of those things, and it matters. But again, other factors could come up against it. If neither of us know anything about boats, or the negotiations were made a long time before the contract was. Again, maybe it was 12 months ago. The courts will place, you might still not win, even though it is, strictly speaking, in writing as part of it. But you're right, if we write out a document, we write this as a contract, and we put things in there in writing, absolutely it's going to be considered to be established. It's very, very hard to prove otherwise that it's not a term of the contract. And finally, the importance of it. This is an interesting case. This Van Eshart's case, Van Eshart and Chapel. This is also known as the white ants case. You guys know what I mean by white ants? Termites? It's a big thing in North Queensland. This whole city is built on one big giant termite mound. When you're buying a house in Queensland, or in this case it was actually Western Australia, again, it involves a real estate agent. Because the thing is with contracts for writing, for houses, all contracts for the sale of land must be in writing. Okay, and so this case actually involved what's called a collateral contract, but they're trying to work out whether or not a particular statement that's been made and around the time of formation is going to be incorporated into the contract or not. One of the important things is how important that term is to one or the other party. When you are buying a house, is it important to you to know whether or not it has termites or not? Of course it is. And so the courts place a great amount of weight on that particular fact when trying to determine whether something the real estate says off the cuff, I don't think it has termites. That matters a lot to one of these two people when buying a house. I think the boat floats. Matters a lot to one of us who's going to be halfway to Magnetic Island when it doesn't. And so this final factor is, again, is pretty important. And here, it was actually to do with the collateral contract, not the main one. But these 5 things the court look at, and none of them are determinative. Just putting something in writing isn't, strictly speaking, going to be enough. Just doing something at the time of formation isn't going to be enough.
Are you just talking about the termites generally, or I think there's some inspection type of stuff before you buy it, they check it?
Yes, you do. Again, the year on this case matters.
Oh, yeah.
So that this is before, a lot of these situations become much more regulated over time. And so the registration, boats, for example, are registered, boats over a certain dollar value as well. But assuming that we're starting with the basic principles of contract law here, so these are the 5 things the courts look at And if you're answering this in an exam type situation where you're being asked, work out whether these particular statements are terms or not terms. This is what this contractual intention test is about. These are the things that we look at as part and parcel of that. All right, I'm going to stop there. I'm going to leave the stream. I'll leave the stream running. And we're going to have a look at some of the quiz questions if we can answer some of them. I'm just going to get some water. I'm just going to take 5 minutes because we started a bit late. I'm not going to have the breaks to be quite as long, but I'm going to get some water. That's all right. We're back in 5.
Fingers crossed.
आपको भी चाहिए होगा नहीं इसको छोड़ दो आदमी इसको तो जाने से पहले मैंने बता दिया I went through this and I think everyone is a taxpayer.
Possibly.
As per my understanding, everyone is. Why?
Everyone's a resident. That wouldn't surprise me. Okay, let's have a little look. Here's a resident, like this registered when you registered. Private company registered in Australia. It's registered in Australia, always going to be a resident. You don't have to worry about reading anything else. Doesn't matter. If it's registered in Australia, that's the way it works.
Yeah, if it's registered, it has to be.
Here, this one here.
My question is,
Yep.
if the
Doesn't matter. Anything else doesn't
if
matter.
the directors are not in the company,
Doesn't matter.
it is a taxpayer, right?
Have a read. Go back to the Go back to the.
But these communities go
Oh, it's awful, eh?
It goes above
This one
my
here.
head.
Company was incorporated in Australia.
So
This is an
no matter
or.
what else, I should ignore the rest. Okay, and this company,
So this one here, private company registered in India, so it's
India.
non-Australia, sure. Runs a business with 3 branches,
but
all right?
it has a branch in this.
That's right, so it's got a business in here, sure. The parents are the directors, but she has the voting system. Now, she is a resident, so the directors, so this mind, this one here, so the control, central management control is not in Australia, all right? It runs a business here, yes. Remember, it's a non-incorporated, so it carries on business, so you tick that one, yes. And essential management control of Australia, no. But its voting power is controlled by shareholders that are residents of Australia. Yes.
So will they be a taxpayer or not?
This one here. So, this carrying the business is true, it's got a branch in Brisbane. Yes.
So the
And
company
either-
is taxpayer?
Either control is here or voting power is here.
Yep.
You need one of those two things. This is actually a statute of rotation. This is an or. So, is the control here? No.
No.
Is the voting power here?
Yeah, one of them is here, right?
Is the voting power?
She owns 60% of the shares. Yeah. So
That's
am
the
I
answer.
supposed to say like this, that this is the tax resident, the company is not, and the directors are, or do I have to say it overall together?
Just say that when reading this, that because, again, you use the language of the section, the voting power is controlled by shareholders or residents. Asha is resident, and she controls 60%.
This company is a taxpayer.
And it's got a business here.
Yeah.
It has to have an
This is tax
and.
resident, right? So all of the scenarios are tax resident. That's what I'm saying.
Possibly. Might be. Let's
And what about this?
Asha's parents are the directors, and she's the sole shareholder, sure. Does this one have a business here?
They have
Packets of
shares.
shares in the Australian share markets might not be the same.
Yeah, because she doesn't have the decision power as well.
No. Parents live there, they're the directors. She's the sole shareholder, so she's 100%. So voting power is here.
But she doesn't have.
No, the key
They're
thing.
saying she cannot take decisions.
That's right. So she receives dividends, all right? So
Yeah.
so in other words, the parents in Sri Lanka
Yeah.
are the central management and control. In other words, that's overseas. Voting power is here, sure, but that doesn't matter. It doesn't
Yeah,
carry
so
on a
this is
business.
not a tax resident,
This
right?
is not tax resident. It doesn't carry on a business here.
And what about this one? I thought this one is also not.
Movement of the money. This one's tricky. It's to do with this extension. At the point in time, it's been extended, so her permanent place of abode. All right. So that she's not ordinarily resident. She hasn't been in here. All right. Or has she been in there this year? I can't remember. This one here. What is she here?
Yeah,
She
went
quit her
there,
job,
she came back
and we're
from
trying to work
Europe.
out whether she's in October. So she's been in the country for over half a year. Right, so this one might apply. She's been in Australia for more than half a year. Unless they're satisfied to usual place of abode, she doesn't intend to take up residence. So what's her usual? Yeah, no, that's that interpretation.
Someone told me that you get these type of scenarios in exam.
The assignments within a scenario like this.
Yeah, so
It's a logic puzzle. Each of these things you could do as a little branch. If A or
what
B.
I'm doing is I need to understand this perfectly
Yes.
to do this.
You must know the logical model.
Because I was doing this and I was just
This is everything. This logic is the logic of the statute. What we think or choose doesn't matter. Other than this one. The ordinary.
all this, you
Yeah.
will not be coming to the university.
For 1 week. Everything's suspended for 1
How
week.
about I solve this and
Yeah.
send this in an email and you can take it?
Absolutely. That's it.
Yeah, because I'm so worried. I'm like,
You'll be fine. It takes practice. It takes practice. Yours as well. That's all. It takes practice. It's a bit of practice to go through and do. Okay, guys, where's the leftovers? Carry on. Where's the leftover sheets, guys? Leftovers are over here.
I need to sign this.
Where's the roll? Where's the leftover? Leftover these. Should be
They
one.
were over there.
One. See them next to anybody?
Oh, it's on your table. They are here.
Oh, did you? Oh, well done. Good job. Does everyone have one of these for today? We'll get started again. Back on the recording. Actually, to be honest, maybe we won't. No, we're going to do some more. I think I might just talk about these. All right, guys, so carry on. I'm just going to talk about some of these because I'm about to go through the ticket cases and effective signature. But the first two questions, the first question is actually similar to one from last week. Oh yeah, go nuts. So it might be worth possibly revisiting that at the end. Yeah, in fact, we'll revisit that at the end. So we'll look at question 2. The decision of Menzies J, the Justice Menzies, in this Egan case. All right, I'm going to bring this up, if I can. Okay. Now, unfortunately, I haven't done this for the benefit of the Okay, guys, I'll just carry on. Just very, very quickly, I'm just going to go through one of these questions. We'll do some of the rest of them a little later, because they're actually from stuff later in this lecture. Justice Menzies is looking at a contract. The case is 1973, and it involves a contractor who organised to do some work for the South Australian Railways Commission. And what he wrote was almost hilariously awful. There he says, "This appeal is concerned with perhaps the most wordy, obscure, and oppressive contract that I have ever come across. It's a standard form contract which requires the South Australian Railways Commissioner that requires those executing railway works for him to sign. It was probably compiled a long time ago, mainly by putting together with some incongruity provisions from other contracts. In this compilation, I'm sure that not one oppressive provision which could have been found was omitted. The contract is so outrageous that it is surprising that any contractor would undertake any work whatsoever for the Railways Commissioner upon its terms. It is, of course, a contract to which the doctrine of contra preferentum, which we'll talk about at the end of today, applies. The employment of such a contract tempts judges to go outside their function and attempt to relieve against the harshness of, or rather, than give effect to, that which has been agreed by the parties.
Courts search for justice, but it is justice according to law. It is still true that hard cases tend to make bad law. So, and again, he goes through, it's a relatively long case. But what he's saying, simply, this contract is the most unfair instrument that he's ever seen in his judicial career. And this is a High Court judge. It blows his mind that anyone would sign this. Right? Nonetheless, guess who won this case? The Railways Commissioner. Because it was, despite the fact it was awful, it was so unfair, and the doctrine of contra preferentum, which is the last thing we'll do today, that says where a contract is awfully unfair and something's ambiguous, you usually construe it against the party who wrote it. That's just what the rule is as such. Nonetheless, it's still a contract. Contract law is not about fairness. It's not what it is about. And so the courts, even though they hate doing it, and they say, look, this is a horrible result for this Egan guy, he signed it. He entered into this contract. It's his hard luck that he did so without reading it. Okay? I'm going to flick back to these things there. That was the only question we're going to do at this stage. We'll come back to some of the other ones. Yeah, because we've got to talk about them first. So, anyway, I'll leave that be. I'll take it off the screen. You can go through and have a little look sometime later. All right, let's go. The next rule we've got to look at is a thing called the parole evidence rule. Yeah, right. Sure. In the text? Yes. Yes.
You will ask us like to know all the perfect terminology.
No, it's not a perfect test. It's a simple explanation. So I recommend to people for the test that you take, and again, somebody asked me for a copy of the all of the lecture slides as a Word document, which I have. I just don't have it on either of the computers. It's my computer at home. I've got to go back through it. That I can just give you guys if you want to take through it. It's basically the lecture slides as a Word document, which can help. It goes a long way, but you won't have enough time unless you've actually can go, because there's quite a lot of little statements to read where you have to work out, this is true, that's false, this is true, that's false. So you do have to have enough knowledge of each of the rules and these little sub-rules to be able to explain it to someone. It's multi-choice, yeah. Which, again, this is the last year I'm going to run it. We shouldn't have multi-choice tests in master's level subjects, but it's a relic of being inherited the subject, and I haven't changed it. We'll change for next year, but to be honest, it's a little bit easier to do, usually, than the assignments, which are crazy, or have been in the past. Probably not going to be so bad this year.
Access to examples of that you've done in the past?
I can. I have to clear it with the person, but I've got a week, so I'll go through that. I will definitely be able to give you guys a sample quiz, but it won't be the exact same questions you're going to get. Is that okay?
Just to see
The style? Yeah, sure. I can do that.
Yeah, and I saw in one question you're going to give us 7 options. Like 7
Some.
options?
Well, only the
That will confuse us
3.
more.
There's only 3 possible.
But 7 options are too much.
Well, kind of, except that the way it's written is that there'll be a series of statements, usually 4 or 5 statements. You have to work out of those which are true, false. This one's true, this one's true, that one's false, this one's false. And so the thing at the bottom will say, A, B, and C are true, D and E are false. That's going to be the style of it. So but you said there are little harder ones at the end for that. And some of them are also going to require you to take 2 concepts and see and compare the differences between them. So, for example, in this one here, why do we have the parole evidence rule? Why is this not the same as using misrepresentation, for example? And some to be able to link those 2 things. But there's not many of those. There's only 3 hard questions in the test. The rest of it is essentially the undergraduate. So it is, in fact, I can tell you, it is actually the undergraduate test as part of it. So as I said, it's relatively easy marks for the subject. Anyhow, carrying on, this rule is a pretty important one. Yeah, it's pretty important. Strictly speaking, it's not a rule of evidence. So it's not a rule of contract law, it's a rule of evidence. And I hate to say this, I'm so angry. I had to go to QCAT about a matter a couple of years ago. In fact, the class last year, I took my matter and I put it as the assignment for the class that year. I was buying some stationery. And the reason why I was so angry about it is that this went to QCAT. QCAT is a tribunal. And there's one very important thing that tribunals don't have to do, that courts do, and that is follow the rules of evidence. And so I had an argument. I don't know if you guys are aware, QCAT is a mechanism where if you've got a dispute of less than $25,000, you can go and have it heard by 2 justices of the peace. So notary public for most of you guys, if that term rings anything. One of whom has to have legal training, one of whom doesn't have to. And they will sit in the position of a QCAT member. And I, as part of this matter, sat there arguing with them about this rule. And there's a certain point in time where Simon is going, no, it's not relevant. Justice Mason in Collateral and State Railways of New South Wales was crystal clear on this particular point, that if you intend a document to entirely enshrine the agreement, all other statements are not terms. I'll say that again. If the parties come together and say, we are going to enshrine our contractual arrangement into one document, if you intend to do that, both parties intend this, all other statements, oral or written, are not terms. They are excluded by the parole evidence rule, including, in Australia, all pre-formation negotiation statements. I'll say that again for the third time, because again, it's a pretty important rule. If a document, a contractual document, is supposed to have all of the terms and conditions, and the parties agree, this document has all the terms and conditions, then everything else is excluded. They cannot be terms. There's a rule of evidence that says everything else cannot be a term. Because if you don't intend this, you can have oral statements, you can have written statements, you can have all of them combined together. If you agree that it's going to be one document, however long, the other statements are all excluded. It's not to say they don't have legal effect. It's going back to our boat example. If we decide to say, look, we're going to create an agreement and it's going to have these terms and we're going to both abide by them, and in that document, it doesn't say the boat can do 15 knots, it's not a term. The fact that you said it to me as part of negotiations might still have some legal impact, again, when we do misrepresentation next week or estoppel, but it's not a term. I can't, by default, sue you for breach of contract and win. That difference is important, because if you haven't used other areas of law, it gets very messy. Okay, for anybody that cares about my stationery dispute, you may or may not know, when you go to QCAT, you have to pay a fee, and you don't usually get your fee refunded. And to appeal a matter in QCAT cost $400. And my stationery dispute was only for about $150 odd, and so it wasn't worth it. It just literally ceased to be worth doing it, even though literally, was it page 347? Yeah, we even got the page number right. You point out where the error of law was. Strictly speaking, they don't even have to follow it, and they did. Okay. All right, and again, there are these. Again, it comes down to intent in regards to these things. That where I say these are an exception to the parole evidence rule, they're kind of not. All they're saying is that these other things can have legal effect. Estoppel, collateral contracts, and what we call implied terms. Because implied terms aren't things we agree about. So we can have a written contract. I'm going back to the young lady down here, me cleaning her house for $10 an hour. Even if we put that in writing, it's still not going to stop the Fair Work Act sitting over the top and saying, oi, you've got to pay me $16.50 an hour, even though we put in writing $10. Doesn't matter, that's an implied term. All right. So that's kind of the things I need to talk to you about express terms. We've still got a couple of other things, mechanisms that express terms can be incorporated into a contract. And one of those is by notice. And these cases are known as the, some of these known as the ticket cases. Have I got them on there? I think I've got, Thornton and Shoe Lane parking. There's a famous case involving a person who used one of these newfangledy, fancy new high technology parking machines where you get the ticket. All right, this was new back in late 1960s, and this came to court, went to Queen's Bench, the Master of Rolls guy, again, Alfred Denning, I talked about last week. This Thornton and Shoe Lane parking, he had this quite lovely decision where he said, look, when you are taking a ticket from a machine, it's fundamentally different than negotiating a contract with a person. You can swear at it, you can curse, you can jump up and down, you get angry at it, you can kick it. It will remain unmoved. All right? There's no negotiation as part of this. And so a couple of things that came to this in terms of Shoe Lane parking was to do with the time of giving notice of these extra terms. So if you've got multiple places where you want the terms to be, and you come, for example, to a parking building, you have to be able to see those things before you take the ticket. Saying on the ticket, the terms and conditions are contained inside, is too late. The contract's already been formed. And as such, you can say that the terms are elsewhere, but they're not going to be incorporated. They're not going to be incorporated in the contract, means that they're not terms. Which means, usually with car park things, usually what's happened is, it's certainly happened in Thornton, you've gone to park your car in there, somebody's come in, smashed your car up, stolen your stuff. And they're trying to rely on what they call an exclusion clause. It says, if you come in here, you can't sue us if your car gets broken into. And look, if that's a term of the contract, that's fine. You can't sue them. If it's not a term of the contract, then you can sue them. You left your car in their car park and it got smashed. They're responsible for it. And that's how this thing worked here. And that's why, since 1971, all car parks will have the terms and conditions, the big sign, on the outside. Usually on the outside and the inside. But they'll certainly have them on the outside where you can see them. That's why, it's because of that. Similarly, in this Ollie and Marlborough Court Hotel, that involved a hotel putting its terms in, I use the phrase terms and conditions. Conditions actually has a technical meaning, which we'll get to next week, 2 weeks' time. It put a list of all of the extra terms it wanted to incorporate into the contract at the back of the hotel room door. What's the problem with that? Well, by the time you've got into the hotel and you close the door, the contract's already well been formed. And there the court said, look, you can't incorporate terms like that. The person has to be able to see them because they might choose to say no. Got to have a meeting of minds at the time of formation for this to work. Okay, so while terms can be incorporated by telling somebody that the terms are elsewhere, and a common one we have these days is URL. All right, URLs, there isn't a lot of case law on this. Arguably, that's going to be fine. If you say, look, terms and conditions are contained here, you have a web link, arguably, you as the person trying to seek to have those incorporated in the contract, you're probably going to be fine as part of that. Okay. So giving notice is one way of doing it, of incorporating terms into a contract. Another way you can go about doing that is what we call prior dealing. This is really slow to update. Super, super, super slow. I really don't like that. Okay, all right. This happens when you've got long-standing relationships between the two parties. And you can kind of see how this would happen. If you have a contract to buy some materials that you're going to use to manufacture stuff. Say, for example, you own a factory that makes shoes, all right? And you buy 10 tons of leather from a tannery. And they supply that with that, they pay a certain amount. You've got a little written contract at the time, sign it, done, got your 10 tons of leather. And the next week, 2 weeks later, you call up and say, we need another 10 tons. And they come and do that, all right? And what you can say over a long period of time is that people in those organizations might just make arrangements. Can you just come and deliver the usual? You're saying to somebody the usual. Are all the elements of a contract met? Well, probably. They probably are. And the courts have said that, look, you can actually incorporate terms and actually say, this is the contract, even though it might have not been strictly agreed upon 3 years ago. But if we have had this uniform series of dealings, courts are actually happy to say, yes, all of the things that you've been doing and these dealings, you're going to deliver this much by a certain amount, and we can vary it by the way that we go and communicate. And all of this happens, and sometimes it might have changed the original contract, for example, which might have been 10 tons, and then later on it reached a point where it's 20-ton increments, all right? And then if you've been doing that 20 tons for 3 years, one day the factory might be closed. You deliver the 20 tons as you've been doing every 2 weeks, and some little bright spark says, no, the contract here says 10. No, we're not accepting it. We've breached the contracts. Not accepting these goods. But the courts actually hold a pretty dim light on that. They say that, look, provided the transaction has been regular over a period of time, that's usually going to be fine when you're going through and you're doing and having these contractual relationships. You can actually say that those terms, as part of the system of dealing, can be incorporated as part of it, rather than going back and looking at this original document you've got way back here at the start. And so that this, use this with great caution. Because it's usually it's the party seeking to, in this case, to try and go through and rely on there being a contract, are going to be the ones that have to go through and prove this prior dealing, which is difficult from an evidentiary perspective, because you're going to have to grab evidence. If you think about it, over the course of the prior dealings, the more evidence you have to get over a period of time makes it quite hard to go through and do. So I'll tell you that rule. Courts will accept it. They want to see people making contracts and not breaking them. And they're willing to accept this, but up to a certain point. Don't weigh or rely too much on this. The next slide. It's one of my favourites. It's not really my favourite. Lord Denning, again, this famous jurist, described Lestrange's case, this Lestrange and F. Gracob Limited, 1934. He described it as the lowest point of contract law jurisprudence of the 20th century. He thinks this was the worst possible case, the worst possible rule. And this will be one of our questions here, because we've referred to it as Lestrange's case. Yes. I referred to the full case name at the top of your thing there. And it goes like this, and this is the law of the state of Queensland and the Commonwealth of Australia. If you sign a contractual document, the law deems you to have read it, understood it, and accepted all of the terms contained within. I'll say that again, probably twice. If you sign a contract, a document that is represented to you as being a contract, by law, by default, you are deemed to have read it, understood it, and accepted all terms contained within. The act of you signing it is you accepting those terms. And we know, offer and acceptance, we're not changing anything here. That, as you could imagine, is a pretty harsh rule, but it is the law. So that's, I think, in terms of business, a really important rule for you to know. Because if we think about this, people sign things all the time. Have anybody here ever worked in retail or hospitality and had vendors that have come in and said, "I'll sign here, please"? Okay. And signing on behalf of your employer. Again, we'll talk about the rules of agency in terms of that in week 9 or 10. But you can get into a great deal of trouble because this is good law. When I say good law, there are a whole bunch of exceptions to it though. But it is the starting point. You sign it, you're bound by it. That's the starting point. So that's the rule in Lestrange. In French, you ignore the apostrophe, just pronounce it as if it was one word, Lestrange, and Gracob. All right, so the first exception to this is Curtis and Chemical Cleaning, a case that I actually couldn't remember in my contract law shoot today. I couldn't remember the name of this case. That involved a dry cleaners where the clerk was asked, the clerk asked the person coming to pick their laundry up. They said, "Can you sign this receipt, please?" And the person went, "Oh, okay," signed it, gave the copy back and signed another one. Well, it might have been a duplicate, I can't remember, but either way. They've then come back and said, "Oh, no, hang on. All of my clothes are ruined. You put all this dye through them. They're wrecked. I want some remedy here." And they said, no, you signed contract. And on the back of that is the exclusion clause. Remember we make the point, Lestrange's case said if you sign a contractual document, you're deemed to have been bound by it. Well, it turns out if somebody represents to you that this is something else, in this case a receipt, not a contract, then that is the first exception to Lestrange's case. If someone misleads you about the nature of the document. All right, have I talked about this here? No, I didn't talk about it here. And it may be worth thinking about when we look at misrepresentation later on, because misleading somebody as to the nature of a document is quite different from misleading them about the content of a document. Going back to the boat, we have this contract for a boat, the sale of a boat, all right? You telling me, sure, this contract says that the boat can do 15 knots, but we've enshrined it into writing, so parole evidence rule applies. Again, you've misled me as to the content of the document. But if I've signed it, I'm not misled about it being a contract. So it is still a valid contract that I'm bound to. The misrepresentation will give me some remedy that we'll talk about next week, but it's still a valid contract. Whereas interestingly, if you mislead me into thinking that I'm signing a document that isn't a contract, that is an exception to the signature rule in Lestrange. Okay? And so you might want to think about why that is. Might be a good question to put in your assignment or something. I don't know, maybe.
I have a question. Like
Sure.
you're saying, if it's misrepresented,
Yep.
how am I, like, when I'm signing, it's sure, like, it's understood and accepted.
Yeah.
Then how does it go? Like, they say that we were being cheated, we were misguided
Ah.
and stuff like that?
I have to be careful. The word cheating is an extremely problematic word in English. All right, for those that come...
Misrepresented, so how
I'll come up. I'll just explain this. There's a reason for this. I hate that word. I hate it with a burning passion. Very unfortunately, I think you guys are aware, it's in the Indian Penal Code. You guys may or may not be aware that cheating is actually an offence in the subcontinent. So I've had many Indian friends over the years that we've talked to about this. And unfortunately in English, in Australian English anyway, not that I speak Australian English, it also has a meaning in terms of sexual misconduct as well. And it's very, very wide. You try to get people to define what that means, they'll all come up with different definitions for it. So I hate the word. I think English is very, very bad at describing very cleanly different aspects of misleading, deceptive conduct as opposed to sexual innuendo. And unfortunately, there's the same word for all of it. So you'll almost never hear me use that word because I think it's misleading.
So how are they going to prove that they were misleading?
Issues like that in terms of evidence, all right? The evidence in terms of demonstrating this one here will be done through oral testimony. She said this, he said that. So if we had to go to court, if I'm making an argument to the judge, hey, we have this thing here, I was told that it was 15 knots. But Mr. Walker, it's not written in the contract. I was like, yes, but you said this to me. I'm going to have to go to court and prove these things. I'm going to have to go prove it. I only did this. And what you do is that the courts will look at all of the various facts and factors, and they're going to look, if I'm, again, I don't want to delve too much into the rules of evidence. They're very, very structured. They will look, if I put myself out as being a person of good character, they can take the character of the two parties into account. Basically, the two sides are going to tell a story. The story is going to be heard by the judge, and the judge is going to work out which one's more believable. And a really good way to win, by the way, is if the other side doesn't turn up to court. It's a really good way to win court cases. And so just be mindful. Back in the days, you'd have a jury. They would determine which of the two stories was more believable. And often, I know that this is difficult for you guys, some of you guys to see in terms of your own backgrounds and so on, but often it's not about parties deliberately lying to each other. Usually it's about one party or the other being mistaken as to what's being said exactly. And sometimes very specific words matter. And armed with the knowledge from this course, from this subject, you guys are going to know that certain words have important meaning. This is why when you're going and having conversations, so again, if we were going to go to court, and I'm not trying to blow my own trumpet here, it's very likely that me as a solicitor, when negotiating a contract and being able to demonstrate that I've taught contract law for 9 years, that certain aspects of this negotiation, I'm going to know the key words and phrases to listen to. So that part of it, the judge in most situations is going to take that into account. Not that I'm more believable or honest, although I have much larger penalties for doing this than most other people. But you guys knowing the language of law and particular words and phrases to listen out for is something you can put before the court. Hey, I did a business law subject. I know that language that was made that was very promissory, she used the word, I guarantee that it reaches this amount. Those were the exact words that were used, Your Honour. I've written it down. Another good way of proving things, taking notes, what they call contemporaneous notes at the same time. If you have any inkling you're about to have a legal problem, super important thing to know, possibly more important than everything else in this entire subject, take notes. Go into your computer and make notes. Email it to yourself in another email account so you can prove that it was at a certain point in time if you think you're going to have dramas.
If you record something without the knowledge of the person,
that's a little bit tricky.
can you use it still?
Usually not.
It is 100%. So let's say you say that no, I didn't say that the boat can go 15 knots.
Sure. And I've been recording it?
And I've been recording, but I didn't tell you.
That's
and
right.
the judge hears it.
Well, strictly speaking, if you play it in court and you're not allowed to, right? If it's inadmissible evidence, the judge will disregard it. What the trick is to take the recording and carefully write out, she said exactly this, Your Honour, exactly this, and exactly that.
The detective.
No. You as the person who has the recording, you just go and you write it out as part of your affidavit. These crystal clear in terms of doing it. Look, it sounds a little bit silly, but I have looked at many, many affidavits. If you are crystal clear about the exact words that are used, you are far more likely to be believable than people. Because if you think about it, most court cases occur years later. If you take notes at the time, and you can demonstrate that, here, Your Honour, here's the notes I took at the time. You're far more likely.
But I took the notes from the recording.
Sure, that's fine. Write them down. So it's you going and taking that. And again, you can do that at a later stage. That's not too much drama. But yeah, the recording of things is a little bit problematic because the judge can just, strictly speaking, remove that out. But if you put in your affidavit, it's this, 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 and this, it's less problematic. Okay, we're going to move on. All right, so now if you're trying to get things incorporated stuff, sure, if you sign it, you're deemed to do it. But there are some exceptions to that. So one thing the courts do say, and this comes from this Interfoto case, it's an English case, that in situations where you have a clause in a contract that someone's just signed that is really onerous. So here, this library borrowed some slides, some advertising slides, the equivalent of what we would call stock images. I mean, long since done now, but the thing was, they could borrow them, and it was a small amount for the first week, and then every week beyond that, they had to pay something crazy. It was like £7 per slide per day, and they borrowed like hundreds and hundreds of slides. They were a few weeks late returning them, and so despite the fact the contract was only for like £1,000, if that, they turned around and sent them an invoice for £27,000. You can imagine, you're like, sorry, how much? To look at these slides for a few weeks. They went back and said, oh, well, actually, in the contract, it's quite clear. £7 per day per slide. You borrowed 125 slides. That's, whatever I said, $1,000 a day. And you were 3 weeks late, therefore, $21,000, thanks. Yes, but this contract was only for a few £100. You signed it. So that was the argument that the picture library had, but they lost. Because the court said, look, there's a long-standing rule here. Yes, if you sign something, you're deemed to have read it and accept it. However, as an exception to the stranger's rule, if there are onerous clauses in a contract, something that is unusual or outrageous. And look, the bar is actually pretty high. Again, we care about the original amount of the contract and the unusual term, which changes and moves it in a dramatically different direction to what it originally was. Anybody here done physics? Anyone done physics at uni or school? Remember doing like chaos theory? That idea that small changes to a system can have massive impacts later on. So having the butterfly thing is perfect. Thanks, Abhishek. Yeah. So the idea of a butterfly flapping its wings 3 weeks later, flapping its wings in Japan 3 weeks later causes a cyclone to appear in the Caribbean. That's that idea. Small changes to a system over a period of time can lead to radical changes there. Comes up in mathematics too, where you've got I'll leave that aside. So
Let's stick to the law.
Stick to the law, yeah.
Physics and
maths. But it's the idea that a small contractual term that can have a massive or dramatic, very unusual or outrageous impact, the courts will say no. You had to draw the attention of that clause to the party who signed it in order for it to be incorporated into the contract. Even though it's in the document, and even though they signed it, if it's something which radically alters or changes the thing, or is very unusual for contracts of that type, you had to bring the attention of that to the other party. Now, this reason, and also another reason we go from a case called Amadio's case, we'll talk about next week, for unconscionable conduct, is one of the reasons why when you were signing a mortgage, everybody had to engage or had to go through a mortgage instrument where you're signing large sums of money. You have to go through that. And when you're signing that, did you have little red tabs you had to pull off that said, please read this and then sign it? You have to physically pull the thing off and sign underneath it. The banks are very particular about that because they've been burned by the courts. They've been burned and burned and burned time and time again for good reason, because they're they're powerful parties. They have good lawyers. And so and again, when you've got onerous terms in a contract, this is more for business, by the way, not for consumer contract. Consumer contracts, you've got a variety of statutory mechanisms. This is where you've got a business transaction, particularly things like having a lease. You guys have gone through a few leases over the years, and leases can have all sorts of little terms in there that can modify stuff. Just be really mindful. If, when you're reading a lease, something seems really out of whack, you read a few of these, this particular one seems very, very unusual, or it's got a very high amount, so there's a scope for it to really, really change direction, you need to bring that to the attention of the other side. Otherwise, the courts can, even though you've signed it, strike it out. Okay. So a particular type of clause that we look at, which I've mentioned a little earlier, are exclusion clauses. Now, these are things that one party, usually the more powerful party, wants to incorporate into a contract to limit their liability, both in contract law and in tort law. In particular, these are the sort of clauses that get put into a contract where you might get sued for negligence. So most of you guys are doing the MPA, and you're doing the accounting qualification, possibly with the idea of becoming accountants, and through the process of giving accounting advice, you're going to be giving financial advice to people, strategic advice, which is why you're all going to know who Michael Porter is by the end of your course, and guarantee you that. And if you give bad advice, people follow your advice and they suffer some form of harm, they can sue you under two areas of law. Breach of contract, usually you paid them money, and as part of paying them money, they guarantee that they'll provide you advice that's not terrible. They provide advice with due care and skill. But they also owe you a duty in tort law as well, regardless of whether there is a contract. So if you go to your sister and ask her for advice, and she's an accountant, and she gives you terrible advice, is that going to be a contract? No. Remember his sister. Remember last week we talked about this intention to create legal relations? And the homogenous case says that, look, strictly speaking in Australia, you can have a contract with your sister, but you'd have to do it in strict arm's length commercial terms. You go into her accounting firm, you pay her market rate, all right? You pay GST, you do all of the other indicia. In that situation, it might be a contract. If you're calling up on New Year's Eve, the two of you are out, it's 10 o'clock at night, and you're drinking booze or whatever you want to be doing on New Year's Eve, far, far less likely that it's going to be considered to be a contract. She can still give you advice. Also, surgeons. So, let's just say your sister is not an accountant, but instead she's a surgeon, and you've got something that looks like a skin cancer, all right, and you're going to chop it out. Now, if you create a contract, an arm's length contract, to go through it as a commercial arrangement, or even better, if it's a friend, not a family member, and they're a surgeon, and they chop the thing out. If there's a contract, all right, you can sue for breach of contract if you're paying some money. If you can't, if there's no contract, you can still sue in tort as well. Negligence. People doing things, doctors operating, they still have to use due care and skill. It's just that it's harder to prove things in tort. Okay? And so what you find is that these types of clauses, these exclusion clauses, are usually drafted to try and protect the more powerful party from liability for breach of contract and damages in tort. Now, courts hate them. They hate exclusion clauses because they are emblematic of the power imbalance between powerful parties and weaker parties. All right. When you've got two powerful parties, Rio Tinto and BHP, you guys know who Rio Tinto and BHP are? Two big mining companies, massive entities. I think BHP is Australia's largest. Which one? Was? It's not anymore. I don't know. It's big anyway. They're big. They're big entities. They're a very large market capitalization. When they are having a contract with each other, courts don't really care about the exclusion clause. They can have whatever exclusion clauses they like because the other party won't sign it because their legal team's just as good as your legal team. All right? They're fighting it out. Courts don't care about that. Usually, exclusion clauses are put in by companies like Jetstar. Who here has ever had to try and negotiate a contractual term with Jetstar? Who has ever tried to find where Jetstar are actually based? Good luck with that. They're very hard to pin down. Because if you want to enter into a contractual arrangement with Jetstar, do you get to negotiate any of the terms? Do you get to say, no, you're not excluding liability for this? Do you get to do that? No. Jetstar will not negotiate on any of its terms. You sign it or you don't. If you don't like it, what are you going to do? Fly Virgin. Go to someone else. It's not a negotiation. These are our terms. Take it or leave it. They are the powerful party. We are not. So, for a long time, courts at common law have bent over backwards to try and limit the scope of these things, to stop this power imbalance. These days, they're not quite concerned about it. Why? Why do you think that is? Why are courts doesn't really worry so much about these sorts of things for consumer contracts? Why would that be, you reckon, in the last 50 years? Well, it's because of consumer law. Jetstar can't get away with all of the things they would want to get away with because the Australian consumer law, Federal Parliament has said they can't. They can't be misleading and deceptive. They can't exclude consumer guarantees. They are going to have to comply to compensate you for doing things if they make mistakes and so on. Parliament's jumped in. It's not the courts though. The courts hate exclusion clauses generally. All right, so a couple of things to note. That in the process of hating exclusion clauses, if the exclusion clause is too narrow, it only covers a certain type of loss. So say, for example, our boat example. If you decide to put a clause in there that says, I will not be held liable if you using your boat in the state of Queensland and it sinks. All right? Sure, courts may look at that and when I take the boat and I take it more than 12 nautical miles, or whatever the limit is, the territorial limit it is, so that you move into international waters, and then it sinks. Courts will go, you said the state of Queensland. This is international, this is controlled by the Commonwealth. It's not part of Queensland. Therefore, your exclusion clause won't apply. That's the style of reasoning they use. They will look at an exclusion clause and say, if you've made it too narrow, we're going to hold that against you. They don't like them. So if you're doing an exclusion clause, make it broad. We will not be held liable for this boat for anything to do with damage causing from this boat, sinking or damaging anyone at all, in tort or in contract, anywhere in Australia or anywhere else in the world. Yep.
If they are too broad,
Yeah, I'll get to that. Yeah.
can they fall off the cliff and become outrageous and they're not?
Oh, that's right. So this is the next one here. So
let's say I go, as you buy my boat,
Yeah.
okay, great, you are not allowed to sell the boat ever
Yeah.
again in your life for the 6 generations.
Or
to
even
come, whatever.
even better, I will not be held liable for any breach in contract regarding this contract, in tort or in contract. And I rock up, I pay you the $8,000, and I rock up to pick up the boat, and you say, what boat? What boat? It says here. Oh, what are you going to do? Sue me? You can't. It says in the contract, I'm not liable for delivering you the boat because it's breach of contract.
That is an exclusion. But
It is an exclusion clause, yeah, but it's too broad. You can't exclude all aspects of breach of contract. Why? Because that means
it can't fall back and
it can fall. The courts will strike it out if it's far too broad.
yeah.
and I'll strike it out if it's too narrow, they'll construe it as narrowly as possible. If it's too broad, where it stops. Because we think about this, if it's so broad, I can never sue you for breach of contract, you don't have to perform. So you're not providing any consideration. Strictly speaking, it's not even a contract. And so that if it makes it meaningless, makes the whole contract meaningless, they'll strike it out as well.
I have a question.
Sure.
I don't know if it's related to the lecture.
Sure.
Okay. Does the law, or does suing and the whole action and contract about it make sense? Does it follow common sense?
Oh no. Oh no. Oh no. Just wait till we talk about damages. Oh no, you'll be shaking your head and go,
Because
it makes
everything
business
you said
sense.
has
Yep.
exceptions to it. Everything
Pretty much everything, yeah.
Yeah, most
Okay.
of it has
Yep.
exceptions. It feels
Yep.
like it's common sense, yet
Yeah.
no, it's not. So where
Yeah.
did we go wrong?
It's very interesting because the further and the more you learn about these things, you start, and this sort of stuff, this course, you're going to be learning about why. Why do what seems like a very commonsensical set of rules seem very illogical and irrational? Usually, it's the worst, the worst possible system, except for all of the others. All of the alternatives are even worse again. The postal acceptance rule we did last week, we talked about acceptance by it's a terrible rule, but all of the other ones, the courts have worked out over a long time, are also horrible and in fact worse. That's really the where we're at with a lot of legal rules and principles. At common law, it's judges going, yeah, this is bad. In fact, the Egan case that I had up before, hard cases make bad law. That's the exact phrase that he uses. Because in a lot of these situations, you look at it and go, how can this be? How can this poor guy who signed this contract with the State Railway of South Australia have ended up being screwed over? He lost. Lost his house, lost his boat, lost everything. And it's because the alternative of letting judges look into the fairness of contracts is actually a much worse scenario, because then it lacks commercial certainty. When we're going and engaging in bargains with people, we need to have certainty in our system of commerce in order for that to be effective. Judges, by the way, are not accountants. They're not usually the best people for doing that. Parliament is the one that jumps in, and Parliament has the problem of being political. So that's why that can be problematic there as well. But arguably, we sort of say, well, at least Parliament are responsive to the people. Judges aren't. They're just trying to do the best they can do. There are only 7 people on our High Court. They determine the common law of Australia. Good question, though. It is a really, really good question. Okay, it's 1:15. Do you want to stop for 5, or do you want me to go right through to 9 o'clock? It's up to you guys. Stop for 5? I might just stop for 5. Oh, my throat's getting a bit...
Your throat is aching?
Yeah, my throat's real sore.
Are you sure you want to make that statement though?
My throat. Exhibiting flu-like symptoms. Don't touch anything.
And your shirt says law.
Oh, I know. And my shirt, there was a spare shirt, but it's like double XL or something like that. So it's just way too big on me. I'm swimming in it, but that's fine. I'm going to get my, I'm going to get some water, more water. Come back.
really interested because one of the things I'm interested about, what's happening in China? No one knows. I don't trust any of the media. I don't know.
They said that no one in case they come and they're looking in Russia, your friends. It's true. I mean, yes, but just because they shop everything.
Disinfect everything.
And then I saw in North Korea they said zero case. I saw like a thing. And they said case 1, case 0. Case 1, case 0. That's only people on the shop.
Zero cases. Hey, Rob. Yeah.
Simon, can you help me? You have a book or something?
There is some books. I've got an older version. If you want some, I can bring some of them along. I've got old ones.
Which was called books, edition 7 and 8, is that?
Yeah, fine. Yes, fine. I'm from the 6th onwards. 6th edition onwards. I said I might have a 5th edition. 5th edition is no, it's got some bits that are missing. I've got some spares of
You
those.
found 6, 7, 8.
6 and 7, 8. I think 6 is fine. It's basically the one after 2011, which I think is the 6th edition. It's the one that has the Australian consumer law, which is the stuff from 3 weeks time now. That's the major bit, because it talks about stuff. And look, to be honest, the 5th edition, if you do find one, is still kind of the same in the cases, but all the section numbers are different. It refers to the old Act, and so you have to go and you have to cross-reference it. It'll be quite a lot of work. I've got, I feel like I might have an old 5th edition. I don't know if I've got the 6th. I'll have a look. I'll have a look. You have to just send me an email. Send me an email. No, just the reading, just the bits for each book. So if you go to, if you go here,
Each week in the just here, just bring it up. Just here, let's go. So if we go into this thing here, look. Go into this, go to here, do my login. Oh, in fact, I might just be logged in here. No, shut up, big on this one. Jeez, sir. Go to subjects, and we go to CO. CO doesn't matter, internal, external is the same. It's a bit slow. Well, this is still on the recording, so if people go to the external offering and you click on the particular week, so we're learning activity, particular topic, so here we've got terms, for example. So this week, this one at the top is an outline. There's some discussion board questions, and there's some content. So that the slides are in here. So if you do want to get the lecture slides, they're in this one. And this one up here, oh no, don't die on me. No, web pages found. What are you doing? That's not good. Which one? Yeah, that one there. That's not good. I'll have to go and check that. There's this one here going as well. So the formation works. I don't know. I think what I've done is I've actually I might not have copied that URL in properly. I'll check it though. Let's check it right now. So this one here. So if you go through it, it'll show you the readings you've got to have for chapter 4 for that week, for example. It's just that one chapter of that book. Now, again, the chapter number's probably going to be the same between sessions, between the versions, but they'll be comparable chapters 1 to 3, because the rules for Contractual haven't changed on this introductory stuff. So I think they're still organised in the same way. So that's worth going through. Like I said, I've got some spares. I'll find some. Just flick me an email. We'll just arrange something.
I checked with the library, but I couldn't.
The library, yeah, they're different. They're a bit slow in getting those things in. There is some in the JC in the Eddie Marbo library that you can borrow. They're only 2-day loans. There's a bunch from the new ones as well. You should be able to go through and borrow them there if you do need to do the readings, but you've got to be in the library physically.
Yeah, but the thing is, like, I couldn't figure out.
You have to. They're in short loan. They'll be in the section, the law section.
Yeah, I just.
One search. So let's just have a look here. Which one? Sorry, this one here. I've just realised the link is actually not working for this week, so I'm so sorry. I haven't checked it. Oh, cool. Okay, that's good. That's useful. Yeah. And this one here, there's a link.
The questions that.
Yeah, this is there. Okay, cool. That's no worries. It's easy as. What I'll do is I'll have to have a little look. Yeah, it's the one search. One search, JCU. I'm just worried, just conscious about time, that's all. Go to the library and then search for that book. So let's call library, go crawl. Guy's name, crawl, contract law. Yeah. No. Go on, Steve. Hold up.
Understanding business law.
Steve. PhD. No, he's just this one. Understanding business laws. This one. It says the 2019, but there are actually new
But
ones.
29 was.
There is. I think there is a 29. This one here. Yeah. 2019. So checked in. So there's 4 copies of it, and they're all checked in. There. So you need that code.
All checked in, so it's available, or?
It's available. Yeah.
Okay.
Yeah, those things there. So there's 4 more. Let's have a little look. Yeah. Checked in. Once there's 1 that's been taken out. And there's another 3 there, and I think there's also the older version as well. Checked in. There's 9 copies of it, all of which are checked in. Although 2 in Townsville, 1's checked in. There you go. So it should be about 4 or 5 copies. That's the code.
Just take a photo.
Yeah, sure. I should put that in there. I'll go put that in the thing there.
Thank you.
Okay, no worries. All right, team, let's carry on. Right, let's go. All right, now, up till now, I've been talking about express terms. All right. So, the types of terms that I've been talking about up till now are express terms. They're things the parties between themselves have agreed. Okay? They're things that we've just agreed upon. There's been this meeting of minds, and through these basic rules, including the parole evidence rule, the rules for exclusion clauses, for onus clauses, the effective signature, there's a variety of little sub-rules that affect that. But they are things that we are agreeing about. The other types of obligations that get incorporated or included into a contract are what's called implied terms. They are things that we have not agreed upon. We did not agree upon these things. Nonetheless, they're part of our contract and we must perform them. We have to follow these things. Now, courts, as you could imagine, don't actually like doing this very often. So at common law, there's a very high bar to apply terms into contracts. There has to be something wrong. So just note, there's 3 basic ways this can happen. It can be implied by law, in other words, a statute, the ones that we'll be doing in a few weeks' time with the Australian Consumer Law, the Sale of Goods Act, the Fair Work Act, the various state and territory statute of frauds, Residential Tenancy Act, the Sale of Land Act, Property Act, and the Land Title Acts, and so on. And so that these statutory frameworks sit over the top of all of these old common law rules, and they modify them. Things like minimum wages, things by saying contract must be in writing, saying that when you sell a car, you have to go through a series that you have to ensure that it's got a roadworthy certificate, some regulation type things. When you sell goods to a consumer, those goods have to be safe, durable, fit for all reasonable purposes, and so on. So those things come from statute. So I'll start with this one here, which is by law. So this is the more common one. In fact, I've even got some examples. There we go, of implied terms. Now, buying goods by description from the seller who deals in goods, that text comes from the Sale of Goods Act. So by default, when you're selling goods, this rule is going to apply. Sale of Goods Act, you can actually change. So if the parties agree that these particular goods, and we say in the contract, they are not of merchantable quality, this clothing is in fact extremely low quality, we can agree upon that and we can trump that rule. All of the rules in the Sale of Goods Act can be changed through agreement of the parties. However, at the bottom, all of the rules in the Australian consumer law cannot be changed by the parties. So if you're selling to a consumer, you can't say to them, this food is off. I'll sell it to you
for only $1 instead of $10. If they come back to you and say this food was off, you are going to have to compensate them, usually just $1. But you actually cannot exclude those liabilities. Similarly, we're selling things that are unsafe. You're selling products that are unsafe. No matter what you say, this is unsafe. If you are selling them to a consumer, you have to. These guarantees are implied into the contract at all times. There are also some common law rules as well. So there's Brendan Williams that there's an implied term with medical contracts when you're getting medical services. There's actually an implied term. You have access at common law to your records afterwards. That's just a common law rule. It's actually not a statutory rule. In fact, it's a little bit iffy, that rule as well. But I'm happy enough to put that in there, even though it's difficult to enforce. Largely because there's a bit of discussion that whether there's an aspect of confidentiality as part of it, and so that you may or may not actually have, as part of that, this right to go through and access it. But at common law, they argue that you probably do have this right. Employment contracts, that you owe a duty of good faith and confidentiality. When you sign up to be an employee, again, I'm offering to clean your house for $10, there is an implied term that I will not take photos of your house, of, I don't know, all of this nude artwork that you've got there, and then try to blackmail you with you, or do things, take advantage of my position as part of that. We didn't talk about this. Hey, come and clean my house. We didn't say, oh, by the way, don't steal any of my stuff, or let your friends in to come and steal my stuff. It's implied in the contract itself, even though we didn't agree to it. That's through law, this duty of good faith and confidentiality. All right. That one's pretty straightforward. And again, we'll talk about some of the statutory frameworks that sit over the top of these things, sit over the top of common law rules. It's when things go wrong, and this is where things can actually go wrong with powerful players, where the courts have to imply terms by fact. And so this Cadelpha Constructions case is a bit like the carbolic smoke. Well, it comes up a few times in contract law because it involved noisy Italian engineers. It was actually a contract to drill tunnels in Sydney, I think to and from the airport, a long time ago, sort of about 30 or 40 years ago. And the State Railway of New South Wales put out this contract to Cadelpha, and they accepted it. All right. Part of doing this was that in order to fulfill the contractual obligations, they had to run triple shift. All right. And as part of doing and getting this triple shift, the state government promised that they would actually go and try and pass laws allowing them to do that. Okay. And as part of doing this, though, that part wasn't incorporated into the contract in terms of doing it, but that was agreed as part of the negotiations. Hey, you guys need to go and sort this out in order for this thing to actually work. And so a bunch of residents went and sought an injunction that said, "Oi, you can't do this thing at night." The courts granted them this injunction, and Cadelpha then wasn't going to be able to fulfill the contract in time. And they sort of said, "Look, there's an implied term in here that you're actually going to go and do this, that actually go and pass legislation to try and allow this thing to happen." Even though we didn't talk about it as part of doing it, so we reckon it was just an obvious thing that you, with the power to go through and pass legislation that can trump what the courts say. Remember, the courts, Parliament can go through and do this thing, that you'll go through and do that. And so the courts, in this Cadelpha, one of many principles they espouse is, look, that may or may not be the case here, but we can look at the facts and say that, look, courts don't like, first of all, implying terms in the contract. Parties wanted to agree on stuff, they agree on it. If they've accidentally left something out, that's their problem, usually. Try to be more careful next time. But there are going to be some situations where things get silly. And so they said, look, we can't just make that the law. Oh, if the contract's going to be silly, we'll imply a term. what they say is that you have to satisfy all of these things. These are elements. The term that's implied has to be reasonable and equitable. It has to be necessary. So it's got to be reasonable and fair. It's got to be necessary, what I say, to give business efficacy. For it to actually have sort of commercial worth or value. If this term wasn't implied, the whole contract would really be undermined as a legitimate business transaction. They also say it has to be so obvious that it just goes without saying. Homer Simpson, duh. Clearly, the state government in this case would have to go through and do that. At least that's what Collateral tried to argue. It has to be capable of fair expression, and importantly, it can't contradict express terms of the contract. Okay, so you can't try to imply a term into a contract where we've actually agreed on it and put it into the contract that this thing, we aren't going to do certain things. So all of these have to be held true. And look, it's a very, very high bar that the courts go through and do that in order for this to actually, on the facts, try to argue that a particular term needs to be implied. So going back to our boat example here, I've bought this boat. You've been sailing around for ages. Driving around, so it's a motorboat. And when I come to pick the boat up, I go and put it into the water, and it sinks straight away. All right? Is there, with a private sale, so we've got no consumer law, we've got no other statutory thing, we're assuming that we're not applying a term by law. All right? If I go to court, I'm going to have to prove this. I'm trying to argue that there was an implied term that the boat that I'm buying for $8,000 would float. All right? And so that, again, the courts will look at these things. Is it reasonable and equitable? Yeah, probably, for a boat particularly. And again, when looking whether something's reasonable and equitable, what is the key thing that they're going to look at? What is the one bit of information they need to know in regards to this contract? One bit of information to work out if it was fair that it floated or not? Yeah, what's the one bit of information they need to know to determine whether it was fair or not, that it floated or not? Yeah. Did I pay $50 or did I pay $8,000 for a boat of a certain size? Courts are going to look, how fair was the contract? Well, was I trying to pull a Swifty over you? Were you trying to pull a Swifty over me? Courts will look at that. And remember we talked about how contracts, we don't care, the common law, how fair a contract is. Well, when we're using some of these subsidiary rules, the courts do care. They are going to look at how much money the contract was. All right? Is it necessary to give business efficacy to the contract? Well, that might be a little bit trickier.
Is it necessary to?
Is it necessary?
To what?
To give business efficacy. For this contract to make sense.
Sorry, I don't understand the word.
Efficacy? It means for it to be effective.
Okay, yeah. No, I couldn't understand the word.
Efficacy, yeah, it's an unusual word. I don't think, we don't use it much in English, I don't think. So it's not it's from Latin. There we go. Oh, man. Now, with the boat, this contract is $8,000 for a boat, probably as part of this contract, particularly looking at the surrounding circumstances, which are, I'm going to use this boat to take passengers next week, for example. So I'm buying it, I'm paying this amount of money as part of this contract to buy a boat that works. All right? If the boat didn't work, arguably, it would be less. So again, that's part of it. So as a business transaction, an arm's length transaction, would this contract just make no sense for an $8,000 useless boat? That would be that one there. It must be so obvious it goes without saying. This is a bit of a trickier one to prove. Should boats float?
In general?
Yeah. Is it so obvious that it goes without saying when you buy a boat that it floats? Probably. I think so. Capable of clear expression. Can we express a term that says this boat should float? Yes. Yeah. Where things are ambiguous or difficult to calculate with dollar amounts, that's where this one comes up. So, for example, the payment of an annuity over a period of time. We don't know how long the period of time is. That's where that one falls over. Here, doesn't contradict any express term of the contract. In other words, in the contract, does it say, I don't guarantee that the boat floats?
Okay.
If it has that express term, never going to imply one. That's how that works. All right, so again, another thing they tried in this Kid Alpha case was this final one. This is really hard to prove, and it's to do with industries. If there is a custom in a particular industry that everyone knows about and everyone follows, that every person doing a contract in an industry would presume it's incorporated in the contract, then the courts will imply those things. And again, this can be a very technical rule of evidence. I had a friend of mine who was working at the new stadium last week whenever they had the concert or the big game, and she said that she was talking to the plumbers, and the plumber said the plumbing work that's been done is terrible. It's low quality, they've cut corners, this, that, and the other thing. And so, that, for example, it may be presumed in this industry that you use copper, for example. So if they've used polyurethane everywhere, arguably you might be able to imply that those things. But again, as with the third part, it can't contradict an express term. If the plumbers said, we're going to use polyurethane, that's the fact that they didn't use copper is not going to be implied in there. That's the term of the contract. Right? It's pretty hard to prove these things there. And the important thing to note, it's industry specific. So you have to know your particular industry to know what sort of contracts happen and what particular things are done in each of those contracts. But it is a rule to leave on the back of your mind if you're in a particular industry for a long time, when you start to see certain practices that come into that. So just for reasons of time, I'm going to move on.
The case example is both the same for implying terms by fact
Yeah.
and implying terms by custom.
Yeah, sure is. Kid Alpha, they talk about both. It's one of those cases where they talk about a variety of different legal principles. They talk about the parole evidence rule, and then later on they talk about the objective intention test, which we'll do at the end of this lecture as well.
Do we look at the cases when we're going over the material and remember that?
I don't encourage it. And it sounds really strange in law. Don't encourage you to read cases. I encourage the law students to do it. From your guys' perspective, it's knowing the principles. The actual cases themselves in terms of the facts, I don't assess your knowledge of the facts of each case.
They're just there as an example to make us understand the concept.
Exactly.
Can we use them to express our understanding of the concept?
You can. What I found is that in assessment, in both undergraduate and
Not the multiple choice.
no, not that one. No, your written assignment. You can, but what I find is that in doing so takes up a lot of words. And so what I have found is that I try to discourage people from going through and carefully restating the facts of all of the cases as a result. So I've tried to move away from it.
Like we talk about the vote example.
Sure.
So for me, I understand a lot of the stuff
Sure.
because of the vote.
Okay.
So if I explain it that way
Sure.
in the exam without going through the and exam, I'm not being a smart ass.
Yeah, no, I understand.
This is how I get it. This is how the vote is.
Yeah, that is. Although the master level subject, it's the way you'll demonstrate it, the particular rule or principle you have, will be applying it to the factual situation at hand.
Yeah.
Say that, look,
Yeah.
in this situation, it seems unlikely that the collateral contract will form because it wasn't clear that they had entered into a main contract or the parole evidence rule or so on like
Then
that.
I could use the
Yeah. Look, I explained this a little bit earlier, so I'm not going to revisit this for reasons of time. This is when we had the example of the boat. Somebody else wants me to enter into a contract and they provide consideration. I'll give you all of my textbooks in order for you to enter into this contract for the boat. Now, I might have done the boat thing anyway, but it doesn't matter. If this promise is made and my consideration is to enter into this main contract, your consideration is to provide with some books, that's a separate agreement. Each of these agreements is capable of being sued independently of each other, and they can have different parties. Start again.
3 parties or just 2 parties in the contract?
Here, we've got a contract for a boat. All right? If, before we enter into this contract, some third person comes to me and says, hey, if you buy the boat from my sister, I'll give you my textbooks at the end of the year. and I go, hey, that sounds good. Sure. I might sway my decision to enter into this contract. Courts don't like being the destroyer of bargains. So what they will say is that this is now two separate contracts, each capable of being sued upon for breach. So assuming I pay you $8,000, you give me the boat, that contract ends. It's discharged. However, if you don't give me the textbooks, our collateral contract, this baby contract, this is the contract I can go to court and sue on. Even though it might only be oral, it doesn't matter. This one can be written, this one can be oral, that's fine. And, in fact, this idea of a collateral contract happens for the sale of land. Going back to that white ants case I mentioned before, Van Eschart and Chappell, where it talked about white ants, the parole evidence rule applies that says, this contract was intended to be only in writing. The fact the real estate agent said, sure, there's no white ants. What the courts there said is that you, when saying that there's no white ants, is a collateral contract. I'm entering into this main contract to buy the house. That is going to stay. All right? But the real estate has made a promise. Their promise is that the house is free of termites. There's no white ants. That's the consideration they're offering. My consideration is entering into the main contract to buy the house. So the courts there said, this baby contract, this collateral contract, is its own agreement, but it's between the real estate agent and the purchaser, not the seller of the house. It's separate, different and distinct. This contract carries on. The contract, the collateral contract that flowed from the promise that there was no white ants by the agent, this is the contract that I'm now going to sue the real estate agent, not the seller. That's the contract that I'm going to sue them upon. The main one stays afoot. This one is in breach. Why? Because there were termites in the house.
It's better to put collateral contracts always in written.
Oh yeah. Almost all contracts you want to put in writing. So with the books, the textbooks. Yeah. Yeah. I know. That's right. But it's not in the agreement. Yeah, that's right. And they do have this. I mean, I'm not going to talk about it now, but I've had some funny stories with real estates, my own real estate over the years. So just a couple of just noticed that again, these collateral contracts can't contradict the main contract. So if the main contract says the house has white ants, you making a promise that the house doesn't have one actually contradicts a term. Yep.
Okay. If the collateral, if you sign
Yep.
the main contract,
Yep.
knowing the collateral contract,
Yep.
but
Yep.
the collateral is in contradiction with the first one.
Yep.
Which one is invalid?
The collateral contract is invalid. Now,
Even if you sign the first one for the second one, you know what I mean?
we'll assume one has to induce you into the other. Remember that the promise has to be to enter into the main one, so it has to be done ahead of time. Collateral contract can't exist after you've already entered in the main one because it's past consideration. You've already done the thing that you've promised to do. You can't have a contract for past consideration. It's already gone. It's like me mowing your lawns because I'm a good guy, and then a week later we create a contract. We can't create a contract for past consideration, things that are already gone, assuming I did it without expecting to be paid. And so the same thing applies with collateral contracts there. It logically can't be after I've already entered into the main one because that's already passed. That the consideration's already gone. I'm not offering anything because I've already entered into the main contract. So therefore, we can't have a little baby contract because I'm not providing consideration. Does that make sense? Makes sense there. All right. Okay. This bit's important because I'm probably going to assess it. So what do we got? I haven't got enough time. 10 minutes. Sure. Okay. When you are reading a contract, This second point of law says, where there is some form of ambiguity, the courts give effect to an objective intention, not the subjective intention. What does that mean? It means the courts read a contract, and again, here I'm just thinking about written contracts, leave oral ones aside for the time being, and say, what would a reasonable observer, a third party, coming in, reading this instrument, think that the two parties meant? There's ambiguity. Not what each of the parties actually meant. That takes a little bit of just digesting. The courts actually don't care what each of the parties actually meant. Yeah, I know, right? I don't care. It's not actually relevant. And again, this is one of those things where you're trying to work out with this sort of stuff. Why is that? And that is because you are going to court, you already disagree about how the contract is to be read. The two parties have read a contract and they don't agree about what it says. There's already ambiguity. The courts aren't going to go through and say, you're smarter than you, therefore, sorry, you're smarter than you, which way? I shouldn't do that in the class, but party A is smarter than me, or even better, you're smarter than me, therefore, we'll read it your way and not your way. That's not how contract law works. For policy reasons, it's not how it works for business, the efficiency of business transaction reasons. You have to step back. And one of the worst things about law and doing anything with the courts, very hard for us individually when we're caught up with stuff, particularly if it's our own property, it's our own family, it's our own business. We get very tied up and very emotional. It's actually hard to step back from it. And the courts, what they say is that, look, as a result, we're not going to do that. We're not going to look at what the parties actually thought. When there's ambiguity, we're going to look at the instrument and we're going to determine what a reasonable third party looking into this would think. Based on what is a reasonable person? It is, I love this phrase, a man on the Clapham omnibus was famously described in an English case, and it means it's a meaningless phrase. It's an abstract person. In Australia, they use the phrase, a man, notice they use the word man, old school judges from 80 years ago.
It can be a woman.
Yeah, on the Bondi tram. Person on the Bondi tram. In other words, it's a fiction. A reasonable person is an abstract legal fiction, but it is nonetheless the direction we give to juries. Okay, jury, and jurors ask this question all the time. Judge, what is a reasonable person? And every judge will turn around and say, it's what you think a reasonable person is. You, one of 12 of our peers in a jury, it's what you think a reasonable person is. Now, reasonable persons don't get mad, they don't get emotional. Ordinary people do, we get mad. Reasonable people, for example, don't get provoked and kill people. We use a different test for that. You can't use a reasonable person because reasonable people...
They actually bring a person to understand and tell them what they understood and they make judgment.
The reasonable... Well, okay. In the criminal law...
no, I'm talking about the contract interpretation, right?
Sure, yep.
So I had a contract with someone.
Yep.
We had a dispute. We
Yep.
went to court.
We've gone to court.
Bring someone actually to
No, they don't physically do it. Like in theory, you could get 12 people in to do it, but in practice, we don't have juries in civil matters. It's too hard. It's too expensive. So what we do is,
a reasonable third party.
so what we say there is that the judge makes a determination of fact. Now, this is a separate process to the judge making determinations of law. It's the same physical person. She or he is going through the various facts and trying to usually make an argument that says a reasonable person would do this, this, and this. And worse than this, you can't appeal that usually. A reasonable person, in my opinion, is this, and it is the judge's opinion, her or his opinion, would think this contract is to be construed in this particular way. Okay? The subjective beliefs, what each of them actually thought, are actually irrelevant as part of doing that. And usually, you don't look at the pre-contractual negotiations as part of this. We look at just the instrument. If there are two possible interpretations and the judge still can't determine, like again as a reasonable person, there are two possible ways this could go, they will look at wider stuff. But that's a two-step process. If they can determine what a reasonable person is just by looking and reading the instrument, they won't go any further. They don't look out at any other things. They only look at what the instrument says. It does take a little bit of time to get used to this idea of what this reasonable person is. And look, it's actually a pretty important point, because it's not about what I think, it's not about what you think, it's about what the judge, as arbiter of fact, would think when they're trying to put themselves in the shoes of a reasonable third-party observer. Look, I have a little bit more faith in this process these days after doing law for a long time. Judges have had to do this many times, having to go through and determine what's reasonable and what's not. It still can't be defined. That's just the key thing to know. So you won't see that defined in a statute. All right, very last thing. It's a pretty minor rule. Actually doesn't come up that much. When you've got ambiguous terms in a contract, courts by default will rule against the person who drafted it. Why? Because it's your fault. If it's ambiguous, the person who wrote it, it's their fault. Therefore, they can take some of the blame. So if it's ambiguous, we will generally rule against them. If there's two possible meanings, as a rule of contractual interpretation, ruling against the party who drafted it, which usually is the more powerful party, but not always. And it can be complicated, as Northern Marine found, where a contract goes backwards and forwards. So I had to send, when I bought my house, backwards and forwards to the real estate like 8 times because he was useless and didn't see any other things as part of it, all his errors. But beside the point, this is a starting point. Look, it doesn't come up much. It's sort of like a last chance interpretation rule. But just make note, when you are drafting a contract, the courts by default will hold it against you if you make it ambiguous. They want to encourage people to be clear. They want them to be clean in how you express your terms, to be a little bit more, to add a bit more, again, it's that business efficacy. We want people to be able to create contracts and know what their obligations are as a result. Okay. Look, we're kind of out of time for these. I might actually go over some of these at the start of the next session. The trouble that we're going to have is that this session was unfortunate we started a bit late. Sorry about that, it's largely my fault. The next 2 sessions go long. The one next week is going to, or the week after next, is going to go quite long. There's quite a lot of material for that lecture. The one after, it's even longer again. Just by the nature of dividing contract law up into these things, some of the parts are a little bit longer than others. Yep.
The assessment will be clear.
The assessment is clear.
No, we meet in this session, this lecture.
Oh yeah, this is definitely part and parcel. You have to know these rules. These rules is part of it. You'll be assessed on those. I think there's about 4 questions in the test. It's roughly divided. The first 2 weeks don't have that many. There's only sort of 2 or 3 for the first 2 weeks.
There's a chapter that you said we have a choice not to include it in the test. Chapter, the session.
The Australian consumer law.
Can we
You do not have to do the Australian consumer law as part of it, but it is not the. It's actually the week after you do the test anyway. So it's
There's a on session 2 there was a section that was very complicated. I'll send you an email.
Sure. Okay.
Yeah, because I remember you said that after you go through the material, we don't have the test that we don't need because it's very technical.
The stat interpretation part isn't in. Okay, I'll go and have a look.
Twice and I couldn't understand a word.
Okay.
Maybe we should ask.
Okay, sure. All right, I'll go through and check that. Yeah, it was. It was the it's the definition of common law. The definition of common law, 3 different ways of meaning it. I've got to go and remove that question. So yeah, please send me an email. That would be lovely, and I'll go and take that question out. That's a really good idea. Anyway, guys, I'll leave that one there.
Can you talk about the Word document?
Yeah. Again, it's on my computer at home, so I'll have to go through and do it. And look, I've changed a few things in the slides. But I'll send the one from last year. It's still probably easier to just go through and use that than it is to go and recreate the whole thing. And it'll be a Word doc for the entire subject. That's the only thing. So it's quite long. I mean, don't get me wrong, it's the same as you guys getting each of the lecture slides, going file, save as, rich RTF, rich text file, and then putting it into, copying and pasting it into a Word document. It's not, I'm not doing a great transformation as part of this, but I'm happy to do that for you guys and save you the hassle.